We're Team 2, and we'd like to thank you for coming to our presentation for the Ethics Challenge, and we're presenting today as the independent members of the Board of Directors for LeConte Capital. We'd like to briefly touch on the ethical decision-making framework provided by the CFA Institute, which consists of identifying, considering, acting, and reflecting.
Here we have a visual going over the organizational structure of LeConte Capital, and we see Courtney McBride, CFA, as the Chief Investment Officer. Below her, we have the two portfolio managers and the funds that they manage.
So for a major violations preview, we identified 5 situations within this case that have various violations within them across 3 separate categories. The first category being the CFA Code of Ethics. Then, since this is an asset management firm, we also compared it to the CFA Asset Manager Code, where we found further violations. And lastly, we looked at this through a legal perspective and identified law-breaking activities. So there are 3 conversations that take place, and we just wanted to illustrate who those conversations are between and which funds are discussed.
So the first violations we'd like to touch on occurred during a conversation between McBride and Spotswood, in which Spotswood tells McBride about some changes he made in the investment strategy for the funds he oversees. And it is important to note that McBride did mention that she noticed 3 out of the 4 years since Spotswood's hiring, she noticed the funds had been underperforming but did not say anything or act on it. Within this conversation, Spotswood tells McBride that instead of investing in large capitalization, dividend-paying blue-chip stocks, he changes his strategy and opts to take larger positions in unquoted companies and does not disclose this change to investors. This directly violates the CFA Code of Ethics Section 1D, referring to misconduct, and Section 3A and 3B, as well as Section 4A, subsection 1 and 2, 4B, subsection 1, 2, 3, and 4, regarding diligence and reasonable basis, as well as communication with clients and prospective clients. We also saw some violations within the CFA Asset Manager Code, Section A1, B3, B4, and B5, and I really want to touch on B5 because it states that managers must take actions in line with the constraints or objectives of stated objectives, as well as Section B states that they must disclose any changes to investors that have the potential to affect those processes. We also saw a legal violation under the Investment Company Act of 1940, and it violates Section 13, subsection 3, which states that registered investment companies must not deviate from their policy in respect to concentration of investments.
The next violation that we identified is, again, in the conversation between McBride and Spotswood. And this is when Spotswood tells McBride that in order to circumvent the regulator mandated cap on illiquid, unquoted stocks within the fund, he engaged in shares for asset swaps between the LeConte Equity Income Fund and the Patient Capital Investment Trust. We found that this violated the CFA Code of Ethics and Standards of Professional Conduct, Section 1A, 1C, and 1D, which deal with knowledge of the law, misrepresentation of actions, and misconduct, respectively. We also found that within the CFA Asset Manager Code, they violated sections B5A, D1, and E1, which dealt with investment processes and actions, compliance, and performance, respectively. And then we also found that this action violated guidance handed down by the SEC dealing with the Investment Company Act of 1940, and this release number was 5847.
The last violation that we identified in the McBride and Spotswood conversation was in regard to fund gating, where Spotswood is trying to close the LeConte Equity Income Fund for 60 days. However, he failed to mention this in complete, accurate, and truthful information to all of his clients. This has now led McBride to give preferential treatment to his long-term client, the Tank County Pension Fund. This violates the CFA Institute Code of Ethics and Standards for Professional Conduct, Section 3A and 3B, and the CFA Institute Asset Manager Code of Conduct, Section F1, F2, and F4, subsection C.
The next situation in which we identified ethical and legal violations was in the conversation between McBride, Newbridge, and Markle. In this situation, Newbridge and Markle both worked at LeConte Capital's biggest competitor, Stokes Asset Management, or SAM for short. And before Newbridge and McBride left SAM, they started contacting their clients to let them know that they would be leaving the firm and joining a new firm, so that the clients could follow them to the new firm. This violates sections 3A, 4A, and 6A of the CFA Institute Code of Ethics, as well as violating the Uniform Trade Secrets Act, which states that employees are prohibited from taking previous employer clients because they're considered trade secrets, even if the employee did not sign a non-solicitation agreement.
piggybacking off of that same situation, in an effort to transfer client data from Sam to Lacondi in the solicitation of clients, Newbridge and Markle both uploaded the client information to the cloud and then transferred it over to an encrypted storage device, which Markle later took home with her, and they transferred it onto the Lacondi servers, in which they also filled out predetermined client information. This directly violates CFA Code of Ethics Section 3E and 4C, relating to the preservation of confidentiality, as well as the responsibility of managers and record retention. We also saw violations within the CFA Asset Manager Code under Section A2, as well as a legal violation from the Graham-Leach-Bliley Act, Title 15, U.S. Code Section 6801. And given in order to use cloud services, a financial institution must manage a range of channels from the content service provider to the IT systems. This also directly violates Regulation SP, Section 248.10 and 248.11, which limits the disclosures on non-public personal information to unaffiliated third parties.
And for the final situation that we analyzed is the conversation between McBride and Newbridge, where they agreed to allow Fortescue Capital to temporarily invest $10 million into the Unicorn Fund, bringing that fund up to the $30 million assets under management threshold that they were wanting to get to. In exchange for this, they allowed Fortescue to buy and sell shares of the New Horizon Fund with the intent of taking advantage of the difference in opening and closing net asset value and the individual stocks within the fund. This breaks Lacondi Capital's rule against permitting abusive trading, which they define as 6 or more round-trip exchanges within 12 months, and they allowed Fortescue to take 30 round-trip exchanges within 12 months. Furthermore, they stood to gain from these exchanges through the advisory fees, and they chose not to disclose these actions to investors, which ties directly into the CFA Code of Ethics violations we have here, which are 2B, 4C, 5A, and 6A. 6A being that disclosure of conflicts, as members and candidates must provide full and fair disclosures of all matters that could affect their duties to clients. And then we also have 2B here, which is market manipulation, as members and candidates must not participate in activities that artificially inflate trading volumes. And then we also have responsibilities of supervisors and diligence and reasonable basis. Moving on to the asset manager code violations, we have section B2 and 3, which have to deal with market manipulation, which we already cited, and investment processes and actions. Lastly, when we looked at this through a legal perspective, we did not identify any law-breaking activities.
The CFA distinction sets the gold standard in the investment industry, and the members in this case did not uphold the CFA's tradition of excellence, elite service, and responsibility. To summarize the violations committed, we made this visual here that provides the 3 violations we found in the McBride and Spotswood conversation, the 2 violations in the McBride, Newbridge, and Markle conversation, and the 1 violation in the McBride and Newbridge conversation.
In order to deter situations like these from happening in the future, and also with the hopes to resolve damages imposed on any stakeholders, we believe it would be appropriate to immediately disclose the trading arrangements, investment strategy, and fund closures to clients and investors alike. And we also feel it would be appropriate for the Board of Directors to voluntarily disclose all violations to the CFA Institute, as well as the SEC, as well as consider hiring an independent consultant to evaluate current controls. We also feel it would be appropriate to refer all violators in favor of revocation of their CFA charters for McBride, Newbridge, and Spotswood, as well as a revocation of the CFA Level 1 candidacy for Markle. We also feel it would be appropriate to secure the client data and correct the information on those account forms in compliance with cloud security standards, as well as terminate the employment status at Lacondi for all violators.
With respect to long-term solutions, we believe that Lacondi should hire additional surveillance and compliance personnel, particularly surveillance personnel, and then take whatever other steps are necessary in order to facilitate a more ethical environment where these violations won't occur in the future.
So in conclusion, we identified, considered, acted, and reflected on these situations. Thank you, and we will now open the floor to questions.
So can we have them also go back to certain slides? So I just wanted to see kind of what all you highlighted on Spotswood originally. And with some of the things that, I guess, Newbridge and Marco's, or McBride and Marco's, conversation, or is it Newbridge? Yeah, McBride and Newbridge, sorry, so many. So McBride and Newbridge, were there any things that, I guess, any violations that you noticed that kind of, I guess, stood out that, in particularly that relates to McBride? I guess any violations that she did as the manager?
Yeah, so for responsibilities of supervisors, which is section 4C of the Code of Ethics, we see that McBride has a very permissive attitude towards these violations and allows them to keep happening within the fund, which we feel makes her an accomplice in these violations.
Okay. And about the blank statements as well, what did you notice about that?
Somebody else want to take that, or?
Yeah, so with the blank statement accountants forms, if you'll go to that slide, please. Specifically, we saw sorry, it's so far away. We saw a violation of section A2 in regards to the preservation of confidentiality in the asset code manager form. In the filling out of those forms, kind of with predetermined information, it not only violates the preservation of their confidentiality, but it kind of.
If I may,
Yeah.
I think to pick up where she left off, in the case, there's a line when it comes to the client information where, similar to what my other teammate said, where she kind of has this pattern of like permissiveness in terms of being an accomplice in these violations. She mentions that it was okay for them to do these things as long as the information was rectified by a certain time period. And to me, or I shouldn't say to me, the biggest thing that stood out to me in terms of like violations, not only in terms of the CFA Code of Ethics and Standards of Practices, violating things like, you know, how managers are expected to have knowledge of the law and not take part in misconduct. I believe there's also a part of Regulation SP. I'm not entirely sure off the top of my head, honestly, if it's these specific parts, but it deals with non-public client information. And so having that violation on the part of McBride was something that really stood out in terms of that particular interaction.
Okay.
Yeah.
So, in addition of preserving clients' confidentiality, do you think it also should extend to whether it's, you know, the new funds are suitable for clients, or whether, you know, how does the duties to clients, you know, stand?
Yeah, I guess I could start by saying that, like I mentioned, the CFA is the gold standard in the investment industry, and once someone achieves that, the charter, once someone gets the charter, they should be able to use their ethical guidelines, their values should kind of help them when learning and maneuvering through different situations like that.
And I'd like to add that when they were sort of recruiting clients from their previous firm, they didn't even mention that. They just said they would all just be thrilled to follow them along. So I don't think they were remarkably even addressed if the new firm would fit with their clients.
Yeah, they didn't really address if the new firm would fit with the client's best interest, which is something that CFA charter holders should take into account when helping out clients.
And then something else that was also mentioned in the case is, I think on the same page where all this is talking about, or what you're asking about, they talk about the round trip trading and I believe it's in the New Horizon Fund's prospectus. And within that, they questioned the clarity over whether or not the guidelines laid out in the prospectus applied to institutional investors or simply individual investors. And that was something that we were aiming at in our short-term plans of actions in terms of hiring an independent consultant to revise any sort of codes of conduct that they might have in order to clarify the expectations and the interests of institutional investors versus individual investors in their funds.
That's time.
Thank you.
Thank you.
You're done.